Good evening to the participants of the JCJ 2022 main examination, which is going to be held on 26 November 2022 if it is not postponed. So, participant, anyone can unmute and read what I posted on the screen so that I could know that I am with you and you are with me and both traveling the same boat to reach to the destination. Read.
Welcome to participants of JCJ 2022 main examination online class 22-11-2022. Key terms in CPC are dealt in section
Not
19.
Sessions.
Sessions 19. Civil Procedure Code 1908. Professor Dr. Mohammed Saheb Hussain, Professor of Law, School of Law, St. Augustine University of Tanzania, Post Box number 307, Malimbi, Mwanza,
Malimbe,
Mwanza, Tanzania, East Africa.
Okay, that's my mobile number here. Now, without wasting the time, let me go that we continued up to the section 100 of the CPC. So, in the further continuation is, I will make it now. So, these are the key terms we will come across in the CPC 1908. Procedure at hearing. Every appeal shall be in the form of a memorandum signed by the appellant and to be presented before the court. Where a memorandum is not made as per prescribed law, then the court has the power to either reject or return the application to the appellant and can give the party prescribed time to submit an application again. If it is memorandum is not in proper way or not in the prescribed by law, then the court has the power to either reject it or return the application to the appellant and can give the opportunity to the appellant to produce in the prescribed time to submit an application again in a proper form. When an appeal is not made on time, then a statement of reason along with some proof should be submitted to the court, and a court must satisfy from the application that is a reasonable cause for the application not made on time. Who will make the application on time? And who has to be supposed to be made the application on time? Is it the plaintiff or the appellant? Or appellant?
Appellant, sir.
It is an appeal by the appellant will be filed over there. No order of stay of execution of a decree shall be made unless the court decides to hear the appeals. So, when the court hears the appeals only, any order can be executed or passed or execution of a decree can be made. Now, the registry of memorandum of appeal is necessary. The appellate court, appellate court. The appellate court, after calling the respondent to present before the court and ask to give an answer and also ask him to give application, after application, court may call the appellant to pay the security cost. That is the procedure. What is meant by security cost? What is here the security cost? Anyone? Venunath, can you throw light on the security cost?
Deposit.
It depends upon the matter of the case.
Yes. If let's say if the matter is of 5 lakh rupees.
Okay.
The court will say you pay security deposit or security cost, or you tell them to pay security deposit of 2 lakhs or 1 lakh.
Okay.
It is called that amount, security amount.
So that the court will take up the case.
Yes.
The appellate court.
Yes.
The appellate court hearing to the appellant may dismiss the application without sending to notice to the lower court and also without sending a notice to the respondent. Means the appellate court having a hearing and they can either dismiss the application or without sending the notice to the lower court, and also without sending the notice to the respondent. The appellate court fix a day for hearing and give notice to the respondent. If the respondent does not appear on given date, the case will be ex parte. In case the party is not present, but on behalf of the party, if the counsel is present, what will happen? The court may not give the ex parte decision. Is it? The party is not present. At that instant, an ex parte decree will be given. On behalf of the party, if the counsel will appear over there, I don't think that ex parte decree will be given. Am I right?
Yes, sir. Ex parte degree will not be given, sir.
Okay. The respondent may do any cross objection. So what is the cross objection the respondent may do? After hearing the appeal, the appellate court may remand the case, may frame the issues and refer to for a trial, take additional evidence, or require such evidence to be taken. The appellate court, after resetting the issue, may pronounce the judgment. Means all the proceedings, trials will be undertaken before the appellate court pronounce the judgment. Document to be submitted with the appeal. Form number, the order appealed against the 2 copies, order of assessing officer 2 copies, ground of appeal, etc. These are the documents to be attached with the appeal. Pending appeals. An appeal itself does not operate as a stay of proceedings until the decree or judgment, appeal and execution of a decree not stayed. An appeal is filed to appellate court. However, the appellate court can order a stay of execution if the court think it necessary. If the application is made for seeking stay before the expiration of time, means within the limitation period, and if the court thinks it necessary, can grant the execution of stay. So it is a discretion, or based on the merits of the case or the evidence produced or the documents supplied, the court can grant the execution of stay. The probability of loss or party suffering loss, and the party has filed an application to grant a stay, that too without delay, the court can grant a stay. Stay for the execution of a decree. Am I right? Am I right? Yes, it is the same. Execution of a decree may be stayed. Cases. In the case of the Atmaram Properties Private Limited versus Measures Federal Motor Private Limited, stay order can be made conditional to, but the condition attached to stay order must be reasonable. So the reasonableness is dependent upon the case to case, how far it is reasonable. If an appellate court stay of proceedings cannot be in operation for more than 6 months, it has been held by the Supreme Court. Means if the stay also given, it's not more than the 6 months duration, and that is held by the Supreme Court in Asian Resurfacing of Road Agency Private Limited and another versus Central Bureau of Investigation, that is a CBI, which shows that 6 months up to that extent the stay can be made, not beyond the 6 months. Now let us see the general provisions relating to the appeals, section 107 and section 108. That is says about the general provisions relating to appeals. Reference to High Court Section 113, Order 46. There we can see how the appeals work and the reference to the court will be undertaken in the appeals. Now let us see the nature and scope. A court subordinate to the High Court is empowered to refer the case under Section 113. That means an appeal can be made from the lower court to the High Court under Section 113. The court in relation to Section 113 means a court having original jurisdiction. So how many jurisdictions that we know in the civil cases? Number one, civil cases, what are the jurisdictions?
Territorial jurisdiction, pecuniary jurisdiction,
Okay.
subject matter jurisdiction, sir.
Okay. A reference can be made only if there is a question of law or validity of any act or ordinance or of any provisions of the act is involved, can be sought only in a pending suit, appeal or other proceedings. Section 115 deals with the revision. It empowers the High Court to call for the record of any case decided by court subordinate to it. So that means for a district court, the High Court is having the power or right for the revision, and it can call upon all the records that is decided by the court of subordinate to it to check again whether a proper procedure would be followed or not while giving the judgment under the revision. Now see the conditions. What are the conditions? Where any matter involving a substantial question of law is referred by the subordinate to the High Court for its opinion upon that matter is known as a reference. According to Section 113, any court can refer the case to High Court for its opinion, and the High Court may then make an order as it deems fit, subject to certain conditions and limitations. So a lower court or subordinate court may approach to the High Court for its opinion. Then the High Court gives the opinion which deems fit, subject to the certain conditions and limitations. Rule 1, order, how much it is? Is it 66? X is 10, L is 50, and that is 6. Means 50 plus 10, 60 plus 6, 66. Am I right? Am I right?
Yeah.
46, sir.
How much? It is 46,
46.
because 10 is written before L, means you have to minus it. Am I right? If the X is written after L, you can place it. Yeah, I'm sure it is a 46. For the purpose of reference provides certain conditions and limitations that are needed to be satisfied for the High Court to entertain the reference from the subordinate court. These conditions are given below. There should be a pending suit first or appeal where the decree is not subject to appeal. Either decree is not subject to appeal, at that instance, its pending appeal would be there. There must be a question of law or usage having the force of law. But not in the question of fact, the appeal would be made. Of course, there is certain conditions are given over there. If those conditions are fulfilled over there, then the matter will be appealed, even though there is a question of fact. But in general, question of fact cannot be appealed. It's only the question of law or the substantial law would be there. Then it will be appealed to the higher court. The court that is trying the suit or appeal or executing the decree must entertain reasonable doubt on that question of law. As per the provision to section 113, question of law involves questions related to the validity or the provision of any act. Either it's a validity is there or the provision of any act. Then the question of law involves or an act or an ordinance or regulations or any other related questions. The question of law will arise. Who may apply? A subordinate court may refer the case with its own opinion on the point to the High Court, either on its own motion or on the application of any of the parties. That means, suo motu subordinate court move to the ask for the opinion of the High Court, or any application is made any of the parties, then it can be appealed and moved, and it could be heard when there is a involved the question of law. In Manager Metro Railway versus Measures BCL, secure premises, it was ruled that Section 113 is not a provision that enables the High Court to take reference suo motu or order of the reference. It is a provision that it enables the subordinate court to refer the case to the High Court. So, number one, they say suo motu also the court can refer the matter, or any one of the party will take the matter to the High Court for its revision. Power and duties of referring court. To entertain the doubt on the question of law, in Banarasi Yadav versus Krishna Chandra Das, it was held that a subordinate court may refer a case to High Court when there is a reasonable doubt regarding the constitutional validity of an act. When there is a reasonable doubt regarding the constitutional validity of act is concerned, then the subordinate court may refer the matter to the High Court. And that was observed in the Banarasi Yadav versus Krishna Chandra Das case law. Powers and duty of High Court. To make any order as it thinks fit to when the case is referred to it by the subordinate court. 2. Answer or refuse to answer the question in a case and send the case back to the referring court for disposing it. So again it will be sent back to the court from where the matter is referred to the High Court from the subordinate court to try again the case in disposing it, even by the following the from A to Z procedure again to ascertain where the fault lies. To quash the case referred to it, in that matter also, Article 228 and Section 113 in Rana Deb Chowdhury versus Land Acquisition Judge, the court observed Section 113 of the Civil Procedure Code is a statutory provision, whereas Article 228 is a constitutional provision. Section 113 does not relate to the interpretation of the constitutional provisions, but to the question of the validity of an act. Section 113 and Article 228 may relate to a common case, but are not coextensive. So one will deal with the substantial law or the procedures, the another deals with the constitutionality. It was held in Rama Sundari Devi versus Indu Bhushan Bose that under the Section 113, the court subject to certain conditions, may state and refer the case to the High Court for its opinion, and the proviso to this section specifically mentions the case relating to the validity of an act. So if the validity of an act would be there, for the opinion, the subordinate court may refer the matter to the High Court for its opinion. Whereas under Article 228 is concerned, if the High Court is satisfied that case is pending in a subordinate court that involves the determination of the substantial question of law for the interpretation of the Constitution. So, based on the interpretation of the Constitution, where we can top 228 and 113 is gone, where the provision to the statute is validity of an act. That was the difference in the Article 228 and Section 113. So let us see further. The High Court shall withdraw the case and either dispose of the case itself or determine the question of law and return the case to the court from which the case has been withdrawn. So, in the both the way it can be done. Determine the question of law or return the case to the court from which the case has been withdrawn. So either way it can be done to give the opinion, or it can give the opinion also that make a trial from the beginning. Am I right? Am I right? Venunath, can you throw light on that one?
हाँ सर बोलिए सर.
I come across one word remand. Is it remand in the civil cases also there? Because I know the remand is there in the criminal cases.
That remand is different and this remand is different. Both are different.
And that remand is sent to the sent to the trial for the prison and the trials.
That remand is either you send them to the police custody.
Okay.
That's called remand.
Okay.
And judicial custody is not called remand.
Okay.
Only police custody is called remand.
Okay.
And
What about the civil case?
In civil cases, when the matter is sent back to the lower court to conduct the trial, to look into the facts of the case once again.
Oh, the case is remanded to the subordinate court.
Yes.
Okay. Procedure at hearing. The following procedure has to be followed at the time of hearing. As per Rule 1, the court trying the suit or appeal or executing the decree, either on its own or on an application of the parties, will draw up the statement of facts and point of doubt of the case and pass a decree or order contingent upon the High Court on the points referred. So if the High Court has pinpointed certain points based on that thing, it could be take up the issue or take up the case and pass a decree. So after hearing the parties, the High Court will decide the points so referred. Could the High Court hear the party's statement in the... Could the High Court will hear the party's statement?
No. The High Court will never do. In High Court, it's only question of law. It is nothing question of facts. Only the advocate has to talk.
Means advocate makes the represent the party stand to the High Court.
Yes.
So at that time it will decide the points so referred. A copy of the judgment along with the signature of the registrar will be transmitted to the referring court as per Rule 3. So a registrar will sign and send the copy to the subordinate court for the implementation of the judgment. Am I right?
Orders of the court.
Order for the court. Okay, that is the wording should be made. The referring court, on receiving the copy, will proceed on confirmation with the High Court's decision to dispose the case. Okay, whatever the points they have shown over there, Depending upon the guidelines and points, the subordinate court disposed the case of the High Court decision. The High Court has been vested with the power under Rule 5 to make such orders and to amend, alter, cancel, set aside any decree or order referring court has passed or made. So, Rule 5 is very much clear that orders and to amend, or to alter, or to cancel, or set aside any decree or order referring court has passed, means subordinate court has passed or made. As a Rule 7, in case the question arises as to the jurisdiction of a small cause court, a record with the statement of the reason for a doubt will be submitted to the High Court. Means, from the small causes court also the matter refers to the High Court. As per the Rule 7.
No.
In the question of jurisdiction of a small cause court. So here they say, as per Rule 7, in case the question arises as to the jurisdiction of a small cause court, a record with the statement of reason for doubt, a record with the statement of the reason for the doubt will be submitted to the High Court. Is it theoretically, it is practically also done?
Both.
When a provision is there, either it may occur or may not occur, but it should be followed when times occurs. Now let us see the costs. Rule 4 Order 46 talks about the cost of reference to the High Court. It says that if any cost is consequent upon a reference for the decision of the High Court, it shall be deemed to be the cost in the case. When a matter is referred from the subordinate to the High Court for the opinion, the party has to bear the cost. The party has to bear the court fee again.
No.
Means, suo motu the subordinate court sends, or any party will make such a statement to refer the matter to for the opinion of the High Court.
No one can send like that for opinion of the High Court. The lower court will send that application to the High Court
For its opinion.
for its court's opinion only on interpretation of the law.
Okay. If the constitutional interpretation is there under Article 228, if the statute ambiguity or consolidification is there, it is under 113.
Yes.
Review. Say loudly. Is it a house dialogue or is it refer to the... It's a house dialogue. It is not referred to the revision or not referred to the opinion. So review, Venu, mute it. I could hear your dialogues in the house. Mute Venu. Review section 114, order 47. Order 47 in the Code of Civil Procedure 1908 CPC together with the section 114 of the Act provides the procedure for the review. Section 114 merely produces the condition necessary for the filing the application for review to the court by which decree or order sought to be reviewed under the application was passed or made, while order 47 along with the same conditions as enumerated in the section lays down the grounds for review. The other procedural rules governing that are the same. sending from the lower court to the high court of the opinion, we cannot say it's a review, is it not?
It is not review. It is the interpretation of the law where the lower court feels or it thinks that it's not able to understand the law, or when is there any dispute like that, or there is ambiguity in that section, then the lower court sends to the high court for its interpretation.
But when the review comes under the 114, Order 47, in order to understand the legal procedure, two primary aspects of concept need to be born in the mind, which are as follows. Same court, Rule 1 of the order specifically provides that application for review for the decree or order has to be made to the every same court which passed such a decree or made such order. That means a review can be done by the same court again, which passed the order.
Yes.
For the review, the party has to pay the court fee.
No, there won't be any court fee. Already has paid the court fee. Na?
But a double time, why do the same court will again take up the matter from the A to Z?
But it will not, whenever the application is filed for review, the court will not go into the facts of the matter.
Okay.
Because already all the process, it's only concerned the role of law only.
Okay. The interpretation of the statute are concerned.
Yeah.
So now let us see court. The term has not been defined in the CPC, but impliedly interpreted as any court having the jurisdiction to try the suits of a civil nature. Now, such a civil jurisdiction may such as conferred upon the courts by the CPC itself, upon the tribunals by the special statutes, or upon the Supreme Court and High Courts under the civil appellate jurisdictions, or by the Constitution of India. So, review jurisdiction for the Supreme Court. The apex court, therefore, also falls within the meaning of the term court. While hearing any suit of a civil nature, if, however, has been separately empowered with a review jurisdiction under Article 137 of the Constitution. Is it correct? Is it under Article 137 only? Okay, please check it whether I'm right or not. But for the cases other than the civil and criminal, since for such cases, it is being governed by the CPC and a criminal procedure code only. So, they made it very clear, while hearing the suit of a civil nature, if however has been separately empowered with the review jurisdiction, that means the court having the review jurisdiction, Article 137, the Supreme Court, the apex court of the country. But for the cases other than the civil and criminal, since for such a cases it is being governed by the CPC and criminal procedure code only. Review jurisdiction for the high courts. Apart from the power conferred upon it as a civil court, means high court, under the CPC, it has been held by the apex court in the case of Shiv Singh versus State of Punjab. The respective high courts are having the review jurisdiction. It is sufficient to say that there is nothing in Article 226 of the Constitution to preclude a high court from exercising the power of review, which inheres in every court of plenary jurisdiction to prevent miscarriage of justice or to correct the grave and palpable errors committed by it. So, if anyone finds his injustice is done to him and the grave palpable errors has committed over there, at that instance, by virtue of the Article 226, one can approach to the High Court. Is it the form of a review or is it the form of a writ? But as we read it, 226 only for the reads. Does it also goes with the reviews?
No,
Review
no.
provisions are different. So a party can go under the constitutional article. A party can also go under the civil and criminal code for the review. Am I right? Yes. Because in the civil and criminal, we don't say writ. We will say only appeal. Which one is appropriate?
Sir, writs are different, appeals are different.
Then what is 226 appeared here? Why?
There is something called, there are 5 writs. Okay.
No, if the constitutional matter is concerned, we can say writs. But in appeals are concerned under the Civil and Criminal Procedure Act, either civil practice rules are concerned or criminal practice rules are concerned in the respective states.
You also can file under Article 228.
Okay.
Not only 226, under 228 also you can file an
Okay.
appeal under writ. That also comes under writ.
Okay. But different nature.
So, in different nature will be there. But Article 226 exclusively for that 5 writs.
Yes.
Habeas corpus, mandamus, prohibition, all these things, 5 things.
Okay. So order 47, condition for the applicability. An application for review may be filed by any person if such a person perceives himself as aggrieved by. Mute. Venunath, I could hear your house sound.
Arey sir, kya karu?
When you speak, you can unmute. When you don't speak, you can mute.
My son, he talks a lot.
Okay. Let's have some patience now. The class will be over. A decree or order which has been passed or made by any civil court, and from such decree or order, an appeal is allowed. But no appeal has been filed at the time of filing the review application. So when filing the review application, we can't say no appeal has been filed yet. So it is the obvious factor that review application is different and writs are different.
Review application is filed to the same court.
Okay.
Appeal is filed to a higher court.
From the lower court to the higher court.
Higher court.
Okay. However, once the review application is filed, thereafter, there is no legal bar on filing an appeal for such a decree or order. I repeat, the review application is filed thereafter, there is no legal bar on filing the appeal from such a decree or order. I did not get this point. Review application is filed. Thereafter,
no appeal can be filed.
There is no bar on filing an appeal. Means we can file the appeal also.
You can file application.
From such a decree or order.
Anything you can file.
Okay.
But
if appeal
you cannot do simultaneously. You cannot do simultaneously. You cannot
once it is over, then we can make it out.
Only. Yes, not simultaneously.
Not simultaneously. Okay.
Yes.
If appeal is so preferred and decided by a speaking order and merits before the review application, then the review application cannot be continued. Okay, now I got the point. A review application cannot be continued if the speaking order is there in the appeal. If appeal is so preferred and decided by the speaking order on merits before the review application, then the review application cannot be continued. That means If once the appeal is made over there, the later part, a speaking order was given, then the review petition cannot be made. But a review petition can be made later on, you can make the appeal also. So, and vice versa, where review application is heard and decided before the appeal, then appeal becomes liable to be dismissed. Good, good. So, where both are pending, whichever is decided first will be said to have superseded the original decree or order. Operationally, therefore, such original decree or order no longer stands, and hence the other pending proceeding will be stopped. So, whichever comes first, the second will be barred. Is it not? If a review order comes, then appeal will be dismissed. If the appeal comes first judgment, then the review order will be superseded. And it cannot be operative. Estoppel will work over there. Although if the appeal or even a special leave petition, SLP, is preferred whether before the institution of a review or after it, but is not heard and get dismissed for the reason being legally incompetent or due to the application of law of limitation, such dismissal does not create any legal obstruction for filing a review or proceeding thereof, if the decision is otherwise competent to get reviewed on the ground provided in the order. So, to me, I understood both run not together. Either you make the review petition first, later on you can go for the appeal. Or you can make the appeal first, later on you can go for the review petition. Am I right?
It is like you cannot travel. It is like you cannot travel on two boats at the same time.
Okay. Don't that riding two horses at a time cannot be possible. So, a decree or order has been passed or made by any court, and from such decree or order, no appeal is allowed. So, if the question of law is concerned, can the appeal will be allowed after passing the order? Because here say, a decree or order has been passed or made by any civil court, and from such decree or order, no appeal is allowed. That means, if there is no question of law in ambiguity very clearly made, then the decree is the final but no appeal.
Yes.
Is it not?
Yes.
This point of application provides the opportunity to an aggrieved person, in the presence of the legal prohibition of filing an appeal, to get his case reheard or any of the ground set out in the order. Because for each and every activity we cannot go for the appeal. If the matter is not involved, such a substantial issue is there, then no appeal will be allowed. Since this condition being a non-appealable, in one which is a condition precedent for the revision as well, and so the confusion may arise for a layman if he is aggrieved by the decree or order that which of the recourse available should be opted. To consider the issue, it has to be understood that review is wider in scope than revision. I repeat, it is understood that review is wider in scope than the revision. Since the revision can be done only on the ground of jurisdictional or procedural error by the High Court, while, as already discussed, that review can be done only by the same court on grounds for review, as explained below in this article, as much wider than merely jurisdictional and procedural error. So my point is, revision aspect is more or review aspect is more? Review is wider or revision is wider? In appeal we will go for the revision, or in appeal we go for the review? Clarity, any clarification? Participants, both of you are practicing advocates. And hence I need the explanation from you. Of course, I can get also which court having the review powers and which court having the revision powers. If the same court deals again, can you say it is a revision?
No, it is review.
In the revision, High Court means appellant court will deal.
Yes.
That means review can be done by the same court which already given the decree or order or
Because that no, the review why they sent to the same court is that because that court knows the entire facts. That's why it is done to the same court.
Okay. In fact, it may technically be said that if a decree or order is eligible to get revised under the revision, then it is mechanically eligible to review under the review as well, provided such a decree or order is non-appealable. But so is not other way around due to the very specific scope of revision. Or a decision and a reference from a court of a small cause, where reference has been made by a court of small cause to the High Court under Order 46, the decision of the High Court on such a reference is binding, but person agreed by such a decision may apply for review of such decision. So if a person is agreed by that one decision, they can apply for the review of such decision. Who can file a review? Answer is any person who consider himself aggrieved is what that the rule provides and is being legally clear in terms on the face, give the interpretation that a person filing a review need not necessarily be a party to the suit, rather may be one who simply derives a legitimate interest in the suit. According to him, such interest has been adversely affected by the decision of such suit, and therefore any such person would have locus standi to file a review. So in one way, in another way, you can say that he will not be one of the party to the suit. The Supreme Court in the case of the Union of India versus Naresh Kumar, Badri Kumar, Jagad and others held, even a third party to the proceedings, if he considers himself an aggrieved person, may take a recourse to the remedy of the review petition. The quintessence is that person should be aggrieved by the judgment order passed by this court is some respect. That means in one way, in another way, he should be aggrieved, but he need not be a party to the suit. A third person can be. Grounds for review. Review can be filed if there is discovery of new or important matters or evidence which after the exercise of the due diligence was not within the knowledge of the person seeking the review and could not be produced him at any time when the decree was passed or order made. So it will be based on the new and important matter in the evidence which is not covered earlier. Discovery of any new matter or evidence necessarily has to be an important or relevant as to the extent that had been brought on the record at any time when the decree was passed or order made. It would have an impact and might have altered the decision. So discovery of a new matter or evidence is more important, which is not discussed in the earlier decision. Moreover, absence of such important matter or evidence on record at the time of the decision must not be the result of a negligent attitude of the concerned person, and therefore such a person applying the review is required by the law to strictly prove that such a matter or evidence was not within the knowledge or could not be adduced even after the exercising the due diligence, and unless such a proof is given, application shall not be granted. So merely on the negligence it cannot be made. Due precautions also be taken over there, but the matter is not resolved or new ground will not be found over there. At that instance, it can be maintained, further review is maintained. Court may take the subsequent event into consideration while reviewing a decision. However, the fact that the question of law on which decision sought be reviewed has been reversed or modified subsequently by the higher authority in any other case would not make a new and important matter to review the decision. So they said the grounds for the review. What are the new points which are not covered in the decisions? And when the due care is taken by the party, but they could not make it out, but later party they make it out after the decision, then you can apply for the review. Illustration here is given is A sued B for a sum of money alleged to be due under an agreement and obtain a degree for the same, against which B subsequently filed an appeal in the Privy Council. While the appeal was pending, A obtained another decree against B on the strength of the former decree for another sum of money alleged by him to have become the due under the same agreement. Later, Privy Council reversed the former decree in the appeal, on the basis of which applied to the court which he had passed the second decree for the review on the ground of decision of the Privy Council, and so was accepted and held by the court to be new and important matter. So one amount due is taken care of it. But later on we found that the another amount also due. At that instance, we can say that it is a new and important matter because another amount also due, which is very clearly given in the above illustrations. Are same mistake or error apparent on the face of the record? The mistake or error should be such which is very obvious and visible itself on the face of it, and therefore any error found out from the judgment after a long reasoning and law-based analysis cannot be said to be one apparent on the face of record as a ground for review. However, such a mistake or error can be fact as well as the law. Of course, it depends upon the merits of the case to see that whether review is there or not. But I believe that there would not be a hard and fast rule unless until a new facts are emerged over there, where the decision may be different. So illustration here given is non-consideration of the very obvious application of the particular law, such as law of limitation, or particular provisions to the facts of the case, setting aside of the ex parte degree without being satisfied of any of the condition laid down in the Order 9, Rule 13, application of the religious laws, which has not been legally recognized, wrong interpretation as a set of legal issues, where a commission was issued to examine the witnesses in a country where no reciprocal arrangement exists, have been held to be an error apparent on the face of record. So when you can say error on the face of record, when you say a new point has emerged over there, it depends upon the nature of the case, and the new error has come out which gives a different decision, then only the review can be entertained. So any other sufficient reason means before 1992 the application of the term sufficient reason was unrestricted and unregulated. Finally, in the year principle came to be laid down by the Privy Council in the case of Chajjuram versus Neki, which can be summarized as that the third ground mentioned is no doubt giving wide scope to the grounds for the review, but at the same time, the sufficient reason has to be at least analogous justum generis to either of the other two grounds, and the mere reason that decree was passed or order made on erroneous ground that court failed to appreciate the important matter or evidence would not make any good ground for the review, and therefore in such cases the appeal and not review is the remedy to get such a erroneous decree or order corrected. Suppose if the new facts is not found over there and the erroneous decree is there, at that instance it is not a review, but we can go for the appeal. Is it? We can go for the appeal but not review because there is no ground of facts. Illustration, a failure to adhere to the legal provision which required the court to act in a particular manner would fall within the meaning of sufficient reason as analogous to the error apparent on the face of it, of the record. Order of the dismissal of the suit due to default of the plaintiff cannot be reviewed on the ground of misapprehension of the counsel as sufficient reason, but if order was on the face of illegal, then such order may be reviewed. If it seems to be illegal, then such order can be reviewed on the ground an error of the law apparent on the face of the record. If it is found over there, then review could be made. The restrictions are concerns. The order and its Rule 9 excludes two following kinds of the applications from the consideration. Now let us see what are they. An order made on the application of a review, a grant or rejection of the application, either case may not be reviewed. That is number one. Decree passed or order made on reviews, where application is granted, case is reheard, and the decree and order which is passed or made merits of the case superseding the original one cannot be further sought to be reviewed for the second time. But they have given when it should be reviewed and when it will not be reviewed. So the revision is given in the section 115, and the meaning is revision means go through the something carefully, thoroughly, and diligently. Cases can be reviewed by the court. Cases can be revised by the court as it possesses the revisional jurisdiction as defined under section 115 of the Code of Civil Procedure. The High Court has the right to revise the cases decided by the subordinate courts to ensure the delivery of justice and maintain the fairness. So a revision can be made to the High Court from the subordinate court. The nature and scope of the object. The primary object of the revisional authority of the High Court, empowered by the virtue of the section 115, is to ensure that no subordinate court acts arbitrarily, illegally, capriciously, irregularly, or exceed its jurisdiction, and allows the High Court to guarantee the delivery of the justice while ensuring that the proceedings are conducted in accordance with the rule and further of the fairness. It must be noted that judges of the subordinate courts have the absolute authority to decide on cases. They don't commit any jurisdictional error even when they wrongfully or extrajudicially decide a case. The High Court has the power to revise these jurisdictional errors are committed by the subordinate court. This provides an opportunity to an aggrieved party to rectify non-appealable orders by a subordinate court. So when the subordinate court is erroneous in giving the judgment by following the different law of interpretation, and such thing we can appeal for the revision in the High Court. The High Court can revise any case by a subordinate court in which no appeal lies when the subordinate court has exercised the jurisdiction not vested in by the law. The subordinate court has failed to exercise the jurisdiction vested in by the law. The subordinate court exercised jurisdiction illegally or with the material irregularity or in the breach of some provisions of the law or by the committing some errors of the procedures in the course of the trial which may have affected the ultimate decisions. So those are the grounds where we can make it out. Who may file? What revision? The application for revision can be filed by any aggrieved party once the case is decided, provided that there is no appeal against the case presently. The High Court may then decide to revise the case if the proper cause is discovered, such extrajudicial activity or illegal and erroneous procedure practiced by the subordinate court. The High Court may also exercise revisional jurisdiction suo motu under the Code of Civil Procedure Code. When the extrajudicial activity is made, illegal and erroneous procedure will be practiced by the subordinate court. In the case of S. Muthu Narayan versus V. Pulraj Naikar 2018, the revision petition is dismissed and the order passed previously is confirmed as the revision petitioner has no right to challenge the executability of a decree. So the revision petition is made it out and that he could not challenge it because that is the final. Condition for the revision. The condition when the High Court can exercise the revisional jurisdiction as laid down in the section 115 of the Code of Civil Procedure. All these conditions must be met with the High Court to exercise its revisional jurisdiction. So these are as follows. Precedents. Yes, once the case is decided and it will be a binding factor, the same cause that could be used as a precedent. So here the case must have already been decided and judgment declared by the subordinate court. A case cannot be revised, and if it has been decided in the first place and no judgment is given, the expression case decided was not defined in the CPC 1998. This gave a rise to a number of the conflicting decisions on the question of whether the said expression included an interlocutory order also. This conflict was resolved in the case of Major S.S. Khanna versus Beg, the FJ, Dillon, 1963, which declared that Section 115 applies even to interlocutory orders. That was observed by the Shah J. The expression case is a word of a comprehensive import. It includes civil proceedings other than the suits and is not restricted by any contained in the Section 115 to the entirety of the proceedings in a civil court. To interpret the expression case, how the case would be. What is the expression of the case? A case is an entire proceeding only and not a part of the proceeding would be to impose unwarranted restriction on the exercise of the power of the superintendents and may result in certain cases in denying relief to the aggrieved litigants where it is most needed and may result in the perpetration of the gross injustice. So these are the revisional conditions who can play and what are the grounds. So that is decided. In the case of the Baldev Das Sivlal versus Filmistan Distributors India Private Limited 1969, the Supreme Court held that a case may be said to have been decided if the court adjudicates for the purpose of the suit some right or obligations of the parties in controversy. Every order in the suit cannot be recorded as a case decided. I repeat, every order in the suit cannot be recorded as a case decided. As an explanation was added to Section 115 by the Amendment Act of the 1976 on the recommendation of the Joint Committee of the Parliament. This makes it clear that the expression case decided includes, I repeat, case decided includes any order made or any order deciding on an issue in the course of a suit or any other proceedings. Thus, any case which has been decided means each decision of which terminates a part of the controversy involving the question of jurisdiction. Either jurisdiction is concerned or the case is held is concerned. It will be the case because it is decided by the court. No appeal lies on whom. There must not be any appeal lying against the case decided by the subordinate court. The High Court cannot revise a case if there is a pre-existing appeal against the case as the revision interferes with the appeal and vice versa. The revision can only be filed once the appeal is dismissed. I repeat, the revision can only be filed once the appeal is dismissed. The word appeal includes both the first appeal and the second appeal. Therefore, the revision can only lie when the appeal is dismissed or does not lie. So now it is very much clear that when a person go for the revision, the answer is the appeal when it is either the first appeal or the second appeal. If the appeal is dismissed or does not lie, then the revision can come to the picture. So jurisdictional error is concerned. The revision jurisdiction can be applied by the High Court when the subordinate court appears to have acted in the excess of the jurisdiction vested in it by the law or failed to exercise the jurisdiction vested in by law, either beyond the jurisdiction or not exercising the jurisdiction, or displayed the material irregularity and exercised its power illegally or in the breach of the provision of law. In these cases, there is a jurisdictional error. Then subordinate courts. Subordinate court means High Court cannot exercise the revisional jurisdiction unless a case is decided by the court which is subordinate to the High Court. Only a court of civil judicature is considered, and this does not include any person acting in an administrative capacity. So that is one of the points. As a general rule, where it is provided that a matter should be decided by a particular court, the presiding officer of such court will act as a court. But where it is provided that a particular judge should decide a matter, the provision of the statute will have to be considered for determining whether the judicial officer act as a court as a person designator. Means he is appointed as a person designated for the court. The revision by the High Court is mainly done to rectify the jurisdiction or the procedural errors caused by the subordinate courts. That is, it is done only in the revision. And in the course of, if any error would be there in the matters, yes, proceedings in any case when the application is filed by the aggrieved party. So these are the terms. Then alternative remedy. The power of the revisional jurisdiction and its application lies on the discretion of the High Court and can't be claimed as a right by any aggrieved party. Several factors are considered before the authority revisional jurisdiction is exercised. if there is in the presence of an efficacious and alternative remedy available to the aggrieved party, the court may not exercise the revisional jurisdiction and instead suggest the alternative remedy and relief to the aggrieved party. When there is the alternative remedy to the aggrieved party is there, and that will relieve the aggrieved party, at that instance, court will not encourage the revisional jurisdiction. This is done to prevent the misuse of the revisional jurisdiction and make it applicable only in cases where necessary. Means you should not use as a sword, we should use it as a only shield. Okay. Limitations on the revisional jurisdiction. Article 131 of the Scheduled Limitation Acts provides a limitation period of 90 days for filing the revision under the Code of the Civil Procedure from the date of the decree or order sentence to be revised. So the limitation period is given in the 90 days from the date of the order or decree passed over there, and thus the limitation period prescribed for filing the revision against the impugned order of 90 days. The application for the revision must be filed within the High Court within the limitation period. Suppose the 90 days is over. Could the High Court will condone the delay if the sufficient cause is shown? When or not? Participants are present or disappeared. Only 5 minutes are left still. Gausia. Sir, today you are going like a bullet train, sir. It is a self-explanatory. Am I right? So, Hosea, limitation on revisional jurisdiction is concerned. Article 131 of the Scheduled Limitation Act provides a limitation period of 90 days for filing the revision under the Code of the Civil Procedure from the date of the decree or order or sentence sought to be revised. Thus, a limitation period prescribed for failing the revision against the imperative order of 90 days. The application for the revision must be filed with the High Court within the limitation period, that is the 90 days.